everybody who's a victim of negligence or malpractice or who's injured, like, they feel a sense of helplessness and hopelessness, and the process of litigating is sometimes daunting and overwhelming. But to add on top of that, not speaking the language necessarily or fluently speaking it, it's like an additional layer of helplessness. So I think as lawyers, we do need to be mindful of that, and I'm sure you have to deal with that. Like, you're not only trying to help somebody who's been wronged and really hurt, but also the process itself can be confusing. Hey there, everyone. I'm Tom Bosworth, and this is the City of Brotherly Law. Welcome to Philly's Legal Pulse, where we chat with some of the city's and the country's best attorneys about what's really going on in our courts and our communities. Let's dive in and see what's brewing in the City of Brotherly Law. Anderson.
How's it going, Tom?
Good, man. How are you?
Good. Glad to be here. Thanks for having me.
I'm glad you're here. Yeah, you're a West Coaster, I think, right?
Exactly. I'm out here in San Francisco.
Nice. So yeah, it's lunchtime here, and you're just getting your day started there, I guess.
Exactly.
Yeah, I'm grateful that you're here, and I've read a lot about your bio and your story, and but I don't want to speak for you. So can you kind of just you're obviously a lawyer. Can you tell us like how you got there and what your background is?
Sure. So I'm Anderson Franco. I'm a personal injury lawyer here in San Francisco. I born and raised in San Francisco. I didn't go too far at all. I went to UC Berkeley for both college and law school. And out of law school, I worked at an insurance defense firm for a handful of years. And then about 5 years ago or so, I started my own practice I only handle personal injury claims. And a bulk of my practice, I'd probably say about 80% of my clients are Spanish speakers. I'm a native Spanish speaker. My parents are immigrants from El Salvador. So a lot of that has guided my practice in the personal injury world and representing Spanish speakers.
That's great. Yeah, I have a lot to say. You're bringing me back to a case right now that I handled, involving a family who, it was a medical malpractice case, and the gentleman passed away, and he only spoke Spanish. Him and his wife they were together for like 60 years. They moved here to Philly from Dominican Republic, and he like never learned English. He was just like one of the like family guys. He was like, a great guy. The reason I'm bringing this up though is that it kind of became an issue in the case in the sense that the hospital had an interpreter, and they treated this guy horribly. I mean, they ended up he had a trachea in, and he was like coming off of a stroke, and he was pulling at lines and stuff, and they knew he was pulling at lines, and they should have like been sedating him because that's what you do, and they didn't. And he yanked out his trachea, and then he went without oxygen for like 7 minutes, and they then sent the code team to the wrong floor, which delayed getting him airway for another 12 minutes, and he suffered a permanent, irreversible, what we call anoxic brain injury, and was never able to speak. He was basically in a vegetative state. And one of the defenses, I call it a defense, that's a bit generous, excuses was, he spoke Spanish. And even though they had an interpreter on staff who had been like collaborating with the family and stuff, and I remember reading, I'm sorry, I'm going on a tangent, but I think that this will allow you to talk too, because you have experience more than me in this. But the medical record documented what was the term they used? Quote, a cultural barrier. That's what they said. A cultural barrier. One of the nurses put in there about him speaking Spanish. And I grilled her about that for like an hour in her deposition. And she like wouldn't admit to me for a half hour that what she meant was he spoke Spanish. And it became this, and then it became a thing where the defense was trying to like devalue the case because of it, because he was a Spanish speaker. And I found myself, by the way, I don't know any Spanish. I'm like a grade A gringo, but I remember thinking, like, I had to mediation in a settlement conference, I really ended up yelling at the other lawyer. I said, if you think for 1 second that this case is going to be like we're going to compromise the value of the claim or anything having to do with the language, then you are you are wrong. I just want to get that out there. You need to understand that there's not going to be any further discussion about it. And we ended up settling it for he ended up passing away. God bless him. We settled the case for 4 times more than I think, and he was like 83 years old, but we settled it for like a ton of money because the negligence was really bad. The point I'm trying to make is, and you've worked for the dark side too, so the insurance company, no offense, but how do you see these things bleed into your practice in terms of people being wronged and then you having to not just take up for them and advocate, but also sort of push back against some of these societal I don't want to say stereotypes or however you want to phrase it. That was supposed to be a concise question, and it was actually just speech. So I'm gonna shut up now.
You bring up a very good point in the translation of Spanish language. So I'm a native Spanish speaker. I'm fluent in Spanish, but amongst Spanish speakers, there's different dialects and different vocabulary.
Right.
So, for example, the Dominican Republic Spanish is different from the Mexican Spanish or the Central American Spanish. And what I've noticed in representing my clients is I have a good command of the Spanish language, but I could also understand when there are discrepancies between the translation that's happening. For example, in depositions, I've had interpreters who are more familiar with one version of Spanish, and I represent a client who's a different dialect. And I noticed during the translation that there are translation errors because I'm a Spanish speaker. So there are moments where I stopped the deposition to ask the interpreter, did you interpret the correct word? And can you please take out a dictionary? And that's one of the benefits of with having a lawyer who speaks the same language as my client, not necessarily the same dialect or the same vernacular of Spanish, but I at least am in tune with that. And during breaks at depositions, I ask my clients to make sure that they're comfortable with interpreters. And there have been times where I have to stop a deposition and request a new interpreter because it's clear to me that my client's just not jiving with the style of the interpreter or the words that the interpreter uses. So that's one area where I feel like that's a reason why I particularly enjoy representing Spanish speakers, is because it's one thing to have a Spanish speaking assistant where I could use an assistant who helps me communicate with the client. But in those moments of deposition or mediation or trial, it's necessary to be able to have that one-on-one communication. And it helps me be in tune with it's the little details that help in being able to speak the same language as my clients.
That's a great point. And some of our listeners who aren't lawyers might not know like what a deposition is or what that entails, but it's like literally the lawyer asking a witness questions, not in a courtroom, but there's a court reporter writing everything down. And then like Anderson's talking about, if someone speaks another language, you have to have another person in there, the translator. So it can get really hairy. Like it's the lawyer asking a question in English. The interpreter then spits that question out to the witness in whatever language, in this case, Spanish. The witness will respond in Spanish, and then the interpreter will say whatever they said in English. And then the court reporter is writing this down. So I think to your point, Anderson, there's a lot of opportunity for error there. And having that ear and having that keen understanding and being a Spanish speaker, even if the dialects do change, which I know that, but that's critical. And especially we know how important every word is in a deposition. It's under oath, it's testimony. Yeah. It also just makes me think like how, I've represented numerous Spanish speakers or people who speak different language. And I always am touched at like how helpless they feel. Not everybody who's a victim of negligence or malpractice or who's injured, like, they feel a sense of helplessness and hopelessness, and the process of litigating is sometimes daunting and overwhelming. But to add on top of that, not speaking the language necessarily or fluently speaking it, it's like an additional layer of helplessness. So I think as lawyers, we do need to be mindful of that. And I'm sure you have to deal with that. You're not only trying to help somebody who's been wronged and really hurt, but also the process itself can be confusing.
I definitely agree. I have many conversations with clients where I empathize with them, where I understand that they did not ask to get rear-ended by another driver. They didn't get asked to get hit by a car while they're crossing the crosswalk. And now they have to take time out of their day or time out of their life to speak to me, a complete stranger, to explain to me their story. And then they have to go to the doctors and then sit for depositions. And I completely empathize with my clients that they don't want any of this to happen, but yet at least there's ways that I can empathize with them and let them be seen and understand the emotional side and recognize that these are difficult times for them. And at least one way it helps is being able to, for me, the lawyer, to communicate with them directly instead of having to use translation services. So there are all a lot of these little details that help in being able to serve the community that I serve.
How did you go from, because not everybody escapes the clutches of the evil insurance industry. How did you how did you go? How did you go? No, I'm kidding. Not really, but how did you go from insurance defense to now I think you're running your own firm, right?
Right, right.
Yeah. How
So,
did you go from that to then now you represent victims only at your own firm? That's
so
awesome.
everyone has their own route or journey to becoming a plaintiff side attorney. I, out of law school, thought that the best way to learn would be from the defense and to get hired by insurance companies, because I thought that, for a couple of reasons. One, when you're an attorney for the defense, the way you get your compensation is you bill by hour, or technically we bill point one, which is we bill in 6-minute increments. So my understanding was, if I work for the defense, I will be able to bill, and I will be able to learn while billing clients, which is insurance companies. And I felt like that was going to be a good method for me to learn the law early on, because in law school, as we all know, we don't really learn how to practice law in
Not
law
at all.
school. You learn how to practice once you become a lawyer. So I felt like being able to bill a client to learn and to research was going to be it was going to be a good opportunity for me to learn early on. And then the second thing is, I always understood that I was going to do plaintiff side eventually. And a lot of plaintiff side cases is against an individual, but that individual has insurance. So really, it's an insurance holds the pocketbook. So I understood that I should learn how insurance companies evaluate cases and how they run cases, so that I can use that to my advantage once I went into plaintiff side. So that's why I worked in insurance defense. So technically, I represented individuals and businesses, but then they had insurance. So my true clients and people who paid us with insurance companies. So I was able to learn the process, talk to adjusters day in, day out, understand how they evaluated cases, understand what it was that they were concerned of in certain cases. So I did that for about 5-6 years, and I learned that process so that I can now use my powers for good, as I say now. So after about 5-6 years of doing that, I switched to the plaintiff side, and now I go against the same insurance companies who I used to represent. I've been retained by these insurance companies before, but now I bring claims against them or their insureds.
I love it. I love how you're like literally knew you wanted to do this type of work, but you're like, you know what? I'm gonna cut my teeth with you guys, and then no, that's so true though. I have friends who are lawyers and colleagues who were on the defense side. They have 100% pick up on things and know things that I didn't know because I've only done plaintiff. They absolutely do, and like having been on that side, they know. Yeah, but this is how the adjuster's looking at this, or you may think the defense lawyer is doing this for this reason, but actually this is probably why. You know what I mean? And like, whereas I'm just over here having never been on that side, like, why are they doing that? What the heck are they talking about, right? And so it's helpful to have those people in your circle because that is a unique experience. And it's so important to know and understand that, like you said, you may sue John Smith, the driver, but at the end of the day, what you're paid out or what's offered, it's not John Smith who's going to decide that, or it's an insurance company. And then you're communicating with a lawyer who's not the insurance company. Sometimes they're in-house, but a lot of times they'll hire outside counsels. And then there's an additional mediary between you and the insurance company. So yeah, I guess having seen how the sausage is made, I'm sure that helps you now with being on the other side and representing victims. That's something, if I were you, I would tell people that too. If they hired me, I'd be like, I've worked for them. I know how this is.
It definitely helps, and in particular helps in mediation. So mediation is where we hire a mediator, where plaintiff is in one room, the defense is in another room, and the mediator goes between the two rooms to try to get us to resolve or to negotiate. And in those moments, there's a lot of downtime where I talk to my client, and in those downtimes, I'm able to explain to my client what's happening in the other room, and what kind of conversations are happening amongst the insurance adjuster and their attorneys. And I'm able to have that conversation and set those expectations with my clients because I have been there. I've done 100 mediations on the defense. So I know exactly what's happening, or at least I can forecast of what's happening. And that helps in mediations because it lets me inform the client, set expectations, let my client know why the process is taking as long as it is. It lets me also like plan ahead as to what to expect in movement in terms of settlement numbers, and also, for example, what's important is knowing who's in the other room also during mediation. And these are things I've learned while I was in the defense because I understand that there's different adjusters with different authorities. And if you have a major claims adjuster who's in the room, then you understand that the authority is greater and they're taking their case seriously, as opposed to if they don't have even an adjuster in the room, you know that the lawyer is the only one who has an X amount of money that they can offer. So there's all these factors that go into that I've learned after my time of representing the defense.
Yeah. You should come to mediation with me. I could use it like a good cop because I'm like such a trial lawyer hothead. I go in there and then they say one thing and I'm like, all right, later. Screw you guys. We're going to trial. It's like, no, I'm not like that. I think younger I was like that, and I'll still do it if I need to, but you know what I mean, how those things go. A lot of times mediation I think is used by the defense as, not always, but a lot of times it's used as a kind of a tool to like take your temperature and see where you value the case. And sometimes it's just a complete waste of time. But
Oh,
sometimes it's legitimate and it gets a case settled. So
I will
you have
say
to be mindful of, what's going on. And I'm sure you are.
I will say that deadlines really move cases forward. And when I was on the defense, setting a mediation deadline or mediation date, we'd have to work backwards in terms of when I would have to report to the insurance carrier and when I'd roundtable insurance adjuster. And the truth is, if we didn't have these deadlines and we knew we had to prepare for that mediation date, and if we didn't have that deadline, we wouldn't be as motivated to try to get all our ducks in a row,
Right.
to figure out, can we resolve this case or not. So I will say sometimes mediation is a waste of time, but sometimes, or most of the times, if it helps parties get aligned, so we try to resolve it, get all the paperwork ready, to see if it resolves or not. So that's at least what I saw in the defense.
Yeah. You know what else always like blew my mind thinking about defense lawyers is like, and you correct me if I'm wrong about this, but like as a lawyer for victims, like a lot of my clients don't really want to be like told what's going on unless like they need to know. Some of them want to be involved, but a lot of them are just like, let me know if you need me. Whereas I think insurance defense, like there's a lot of reporting back to we say the carrier, that's the insurance company, and that's usually like an adjuster or someone inside the insurance company who wants to know what's going on in the case. How did that deposition go? How did the defendant do? How did the defendant testify? How does the plaintiff come off? Like, and what always struck me as difficult and something I probably would be terrible at was if I'm a lawyer working for the insurance company and they pay me, for my time hourly, how do I strike the balance between giving that insurance company like a good, honest take on the case and not BSing them? Like, look, I think you got problems here. I think the defense is really weak. I think the defendant testified terribly. I don't think they're credible. When that's the case, of course. But how do you strike that balance between giving them it straight, but also not sending the message that, oh, I'm weak or I'm not going to fight for you and I'm not a good lawyer, right? Because at the end of the day, my defense lawyer friends tell me this, like one of their worst nightmares is reporting back to their client something or giving them too much hope or breathing too much life into the defense, and then that invigorates the insurance company to go to trial. And then next thing you get smacked with a $40 million verdict, and then your client, the insurance company, is looking at you like, "What the heck, man? You didn't tell me this case was so bad." Do you know what I'm saying? Like that. Yeah.
So each insurance company has its own claims handling guidelines, and that governs how often the insurance defense attorney has to report to the carrier. Some have it 60 days, some 30 days, and some also are adjuster specific, where adjusters are more in tune with their cases, so they want more frequent reporting. So the insurance attorney writes the report to their to the insurance adjuster, and to your point about there's different cases. There's cases where it's a clear liability and the damages clearly it should be a policy limit case, and there's the opposite where liability is iffy and the damages are iffy. So at least in my time as a defense attorney, I just reported the truth, the facts, and
Right.
I would summarize depositions. I would explain to them what I've seen in medical records, and then ultimately provide the insurance adjuster with their options. Your options are you can mediate, we can depose these people, we can subpoena here, and often the adjuster would tell me what they want to do, and to your point of not wanting to fold over or not trying to say that appear you don't want to appear too weak or too aggressive. My philosophy on that is as long as I reported all the cases honestly, some cases it's going to seem where I report to the carrier, you should pay the policy.
Right.
On other cases, I report to carrier, this is a very questionable case. So as long as I was honest, I felt comfortable knowing that the insurance company or my clients at the time, insurance companies, would make the right decision based on my assessment. And you're right, it is scary to say to tell the carrier that there should not be a nuclear verdict on this one, and you get close to trial or you try the case and it didn't go your way. And you and I know juries are unpredictable, trials unpredictable. So because of that, I can't. I tell insurance companies, no, you can't predict the future, and the best I could do is tell you what the facts are, what my opinion is, and you tell me what you want to do. So that's kind of the practice that I took on reporting to carriers.
I've also found that, certain carriers or in my case, I do a lot of med mal. So it's hospital systems, health systems. They have different appetites for risk. Some of them are like, let's go, man. Let's do it. Let's fight. And you're like, you have a sucky case. I'm going to crush you. And they're like, we're going to win, and then there's others that are less risk averse. And I remember I had a case 2022, my law partner and I got the biggest med mal verdict in the state of Pennsylvania for that year. And it was against Penn Medicine, who's like a flagship, institution here, health system. And our client was in her 50s, but she was permanently injured for the spinal cord injury. She couldn't work anymore. Like, it was a big case. Liability was not straightforward, but her injuries were severe. And they offered $2 million before trial. And it was like, and I've been in this position before where you're like, they a lot of times the insurance companies or the other side, they'll put you in that position when you're the plaintiff lawyer where they're like, they want to hit that sweet spot of injecting just enough risk to where they know they're paying less than they probably should, but to where it puts enough risk on you or the client to take it. And it's always that kind of cat and mouse game. But in this case, our client was pretty steadfast, and she was like, no, I'm not taking two. And I was 33 years old at the time. So I give my opening statement. I thought it was okay. I called the defendant doctor as on cross-examination as my first witness. And, I'm like crossing him, and I'm like, you can never read too much into how you feel about your own work because you're biased. But I'm like, I think I'm beating this guy up pretty good. But you never know. And like you said, juries are unpredictable. But after that witness, the judge called us in the back, and he made the health system grab like their insurance adjuster, or actually it was this lady named Holly Aronson, who's like technically an in-house lawyer, but she's the money person over there. And the judge was like, turned to all the Penn lawyers, and he goes, there's no court reporter. He's like, yeah, you guys got some problems. Like, that did not go well for you. And I'm just sitting there like trying to, not be too happy. But I'm like, okay, so I wasn't imagining it. And he's like, yeah, I really recommend you guys reconsider where you're at with the 2 million. Like, you don't have to listen to me. I'm not going to hold it against you, but I don't know what you're thinking. And Penn, were just like, but like pretty much dismissive. Like, no, we thought that went great. Like, we think our doctor's great. And blah, blah, blah. And then the jury came back 19.6 million. So, but that can work both ways, right? It's not like that it doesn't always break your way. And it's really difficult, I think, as a lawyer. I think one of the hardest things is finding that midpoint of, you're deciding whether to settle or go to trial, that midpoint of what's best for the client, while also, not devaluing their case and considering everything that could go wrong. There's no hard and fast science to it. But how do you deal with stuff like that? Or do you agree with me, or what do you think?
Yeah, you bring up a very good point that each insurance adjuster is different and has a different penchant for being risk averse or not. When I represented insurance companies on the defense, I saw both ways. I saw cases where I would tell the adjuster, it seems like the other side wants 30,000 and it'll settle for 30,000. And I've had insurance adjusters tell me, I don't care if we spend more than 30,000 in defending this case. I don't think I don't think that we should just pay the money just to get out of it. I want to defense.
True believers.
True believers, exactly. So I've had those insurance adjusters who fight, and we spend more in legal fees and expert costs to fight a case that, and even though it didn't make business sense for the insurance company, that insurance adjuster wanted to do that. I've also had the opposite, where the insurance adjuster really doesn't want a case to go any further and provides a lot more authority than the other side wanted, and it was basically an open checkbook. I've had that happen, and so there's in both moments, and I've had both sides happen. I'm surprised. I'm surprised that you insurance company want to spend more money, and on the other side, I'm also surprised you want to spend more money. So I've seen both sides of it, which is why it's helpful to keep that in mind and to know that not every case, well, we know that every single case is different. You're dealing with different facts, different insurance adjusters. You don't, at least the way I approach my plaintiff side cases is, I don't know what's happening on the defense, like exactly, but I have an idea, and I use my knowledge as when I was on the defense on how I can make moves or strategize in litigation or depositions to kind of tease out what we're dealing with on the other side. So what kind of adjuster we're dealing with, and that's actually why I like to talk to insurance adjusters directly, telephone call, not email, to kind of understand where they're coming from. And to hear the sort of words that they use. Maybe
You can
they
tell
are
pretty quick. You're like, this one's a stickler. Like, they're trying, they'll spend 80 grand to defend this case that could settle for 25. Or
exactly.
like, or now we're dealing with a reasonable person who's not too entrenched in the philosophy of it.
Exactly. Or I'm sure you've heard this plenty of times where they blame our client for causing their own injury. Like this happens particularly in premise liability cases.
Dude, I
I-
Yeah, go ahead.
I had a slip and fall case where we have video of what happened. And of course, I get the call from the adjuster, and the adjuster telling me, Anderson, this is not a good case. You don't want to file this case. Have you seen the video? And I asked the adjuster, do you see like she tripped because of the dangerous condition on the sidewalk? But despite seeing the exact same video, I saw it one way, the adjuster saw it the other way. He said we're not. He said we're not offering anything. We're never offering anything. Fast forward litigation. I think it was a year and a half, 2 years. It was a very successful settlement, confidential. And that same adjuster was at mediation when we resolved it. And I thought to myself, like, you were way better off solving this pre-litigation, and now you guys have to pay a lot more money than what you wanted. Um, it's every case is different.
Never ceases to amaze me how detached from reality some of the insurance adjusters are in terms of like what they think based on reading a deposition transcript versus like how this actually plays out in real life in a courtroom, or how the witness actually comes off in a human component. I mean, I've had so many times where I'm like being told, oh well, they're not going to pay anything, and they think they're going to go in there and blame your client, and I'm like, that is not going to go well, and like and then but they're like, they've got this idea in their mind of how they're going to do it, and I think that I'm pretty good at like dismantling those things in a courtroom. I've done it before, but there's a big um there's a large discrepancy in the skill level, and I think the knowledge base of a lot of adjusters. Some are super smart, and some are very attuned to the realities of what litigation is, and others are not. But it's amazing because they hold the key to the kingdom. So you're really kind of like stuck dealing with them regardless.
I think it's kind of an old school model that the defense uses in terms of evaluating cases is looking at objective figures, looking at how much were the medical bills, how much was the wage loss, what is the specific diagnosis? Is it a fractured femur? Is it just a sprained neck? They just look at these kind of isolated events and then create a number that they think is the value. I've seen that happen. But the truth is, a lot of the value is in the human stories, the human aspect of the person who is injured. Because a broken leg on one person, the value of it could be a lot greater compared to another person. What matters is who is that person? Do they have children? Do they have grandchildren? What kind of hobbies do they like to do, and how has this injury really affected them? So, and I feel like that's where conveying that story as someone who represents injured plaintiffs, I think conveying that story to the other side and letting the other side of insurance companies know that it's not just a broken leg, it's more to that. It's the loss of being able to play with their child or their grandchild. It's the loss of not being able to play tennis the way you do, and then telling that story and how it's really affected their life, and then bringing in their tennis partner or bringing in their neighbor who talks about how much joy these activities brought. So I'm going off sort of on a tangent, but bringing it back a little, I think there's a lot more than just these metrics of the dollar amounts of medical bills, the dollar amounts of your wage loss, and and the sum of those two don't make up the value of the whole case.
No, you're right, 100%. It's not a tangent. It's a really important point, and it's something that I've rejected as an attorney. This formulaic evaluation of a case. I think of a case right now where I had this happen to me. I was a little younger. I was like 32, and it was a Spanish speaker, believe it or not, and it was an 83-year-old young lady named Juanita Martinez, and I can say this, it's all public, it's not confidential. And Juanita's only son in the whole world was her son Jesse. And when Jesse was born, his father left abruptly after he was born, at about 2 months after finding out that Jesse had some pretty serious like disabilities. And he left. And there Juanita was. She raised Jesse alone as a single mother, Spanish speaker in Philadelphia. He had severe autism, severe intellectual disability. She raised him alone, all 4'11" of her, and while cleaning houses for rich people, and really did it really not easy. And he eventually had to go into a group home because he was like 6'4", and he would become aggressive, and it just became like, it wasn't like, it was a couple minutes away from her house and she would see him every weekend, but he had to primarily live in a group setting. And everything was good until it wasn't, and the company or the group home hired an employee who had a horrendous track record, criminal background, had been fired from other companies for mistreating people with intellectual disabilities, somehow gets the job here. There's like no vetting done of this guy. And Jesse was left alone with this gentleman for a 3-hour period in November 2017, while another employee drove some of the other residents to a day program. And when that driver employee came back, he walked into the house. He looked at Jesse. Jesse was on the couch with his head down, not moving, not speaking. And the employee looked at the other employee and was like, "What the heck's going on here?" basically. And, "Have you called 911?" And he said, "No." So 911 was called, and they came and transported Jesse to the hospital. And he had 17 fractures throughout his body, including his sternum, his chest bone. His vertebrae were snapped in his back. His pelvis was shattered, and he bled internally for 40 days and then died right before Christmas. 44 years old. Because mom spoke Spanish, and because it's Philadelphia and there's a zillion people here and they're overworked, and the medical examiner kind of botched the autopsy. They did kind of a half ASS job and basically ruled his death of natural causes, because he did have like an underlying medical condition, and they didn't do their job in interviewing the employee. They just didn't do their diligence. So then they get this autopsy that's like natural causes. And the case came to me, and I didn't, and nobody at my firm wanted me to take it. They're like, "You don't have an autopsy." Literally, the autopsy doesn't say anything bad. It says nothing. The guy was nonverbal. The mom doesn't speak English. And I just was like, absolutely not. Like, we're taking the case. And like literally took the case and took it up to trial. And this goes to your point about like the insurance company the whole time is evaluating it. Just, he didn't have a job. He never worked. He didn't have any future earnings. He didn't have kids. He wasn't married. There's no like numbers I can tell the jury, like cold, hard dollar signs that resulted from this guy's death. Like, it's not like, oh, now he's nothing. And they offered nothing. And then right before trial, they offered $100,000. By the way, in Pennsylvania, you can't ask the jury for a number. When you're arguing in front of the jury in Pennsylvania, you can't say you should award 10 million, or you can't. So I'm literally, it's a crapshoot, but I'm like, absolutely not. And we go 100 grand, and they're like, basically being sarcastic to me about this case. Like, what are you gonna like? Yeah. So I give my opening statement, and there was like, it just talked about how he was Juanita's life. He was her entire life, and he's gone now, and now as part of her is dead. And I didn't like go over the top with it, but it resonated. And then they offered $1 million. I said, absolutely not. My demand was 7 million. Everyone thought I was insane, by the way. They may have been right. "Oh, Tom, $1 million is amazing, blah, 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 blah." I said, "No, it's 7. Called my next witness, their internal company investigator who hid the whole death and everything. Crossed her. She gets off the stand. I get a call from the vice president of the insurance company. "Tom, happy to report, but this is it. This is it, man. We cannot give you anything more. But we have $3 million to offer." "Nope, thanks." Woke up next. Keep calling witnesses.
That one wasn't that one. 3 million there wasn't too difficult for you to say no to.
Nah. The mom was furious. The mom didn't care. She didn't care. She's 84. She's like, they killed my kid. Next witness, Tom, like, we really, really mean that. This is it. This is it. $5 million. I said, my demand 7. Hung up. Next witness was the chief of pathology at Jefferson, which is in Philadelphia, who got literally laughed off the stand after I cross-examined him, and I'm not joking. It involved him going to me, "You don't know who I am," with this raccoon-looking toupee. Anyhow, he was saying the guy just randomly died with 18 fractures all over his body. At one point, he didn't put that that Jesse had that had bruising all over his chest, documented by the ER. He didn't put that in his expert report, and I pointed that out to him on cross, and he goes, "Oh yeah, I guess that was a poor choice of words that I didn't put that in there." I said, "Well, where I come from, we call that lying. Do you agree?" And he got all mad. Anyways, he gets laughed to the stand. Adjuster calls 7 million. 7 million, it settled. They agreed to fire the employee. They agreed to change their policies. They built a tree in her name, in his name, sorry. And the point of the story, and I'm sorry I took up so much time, but the point of the story is that it's our job to reject these traditional ideas of what other lawyers say a case is worth. Right? The case was worth 7 because they paid 7. Because of how bad it was, because of how badly they treated him, and how badly, and all the traditional wisdom in the room. She's a Spanish speaker and he was retarded and all that. All the traditional wisdom suggested I should have settled for 500 grand. So sorry to go that deep, but I do think it's something that we should all keep in mind in what we do.
I completely agree, and that's our main goal or main job as personal injury attorneys. Is we are interpreters. We interpret our clients' hardships and damages in life to the other side, and the other side could be insurance company, it can be the jury or an arbitrator. What we do is just gather all the information, and so that we can interpret their story and translate their story to the world, so that the world knows what the loss is, what the harm is. And you did an excellent job there. That is a very difficult case, but you figured out what the loss was, what the stories are that you had to tell, and you ended up with a good result. And that's the fight that we have to fight. And going back to what we were talking about, where it's not just the loss of the fact that Jesse did not have a job, or the fact that Jesse relied on others for care. It goes beyond that. It's the story of a mother who lost her son, and so that's a lot of the work that we do as personal injury attorneys, is share these stories and have these people be seen. Another thing that I like that you did is you mentioned that there is not just the money, but also a tree was planted, and these sort of uh, sometimes clients want to be seen, and yes, they want money, because in our society, that's how you can receive compensation for harm. But sometimes clients want to be seen. I've had clients who want to agree to a settlement number, but also want the other side to apologize, or to do some
Right.
sort of act,
Mhm.
especially in cases where the other side denies liability or says that they didn't rear end you, or they didn't run a
Right.
red light. I've had situations where at mediation, we agree to this number, but we want the defendant to face say sorry. And that helps. That helps clients move forward and recognize that that it wasn't their fault. So there are these little things that, well, it's not even little things. There are these big things that we can do as lawyers to help our client, kind of not get over the harm, but like help them deal with the harm or the damages from injuries, or from whatever negligence occurred.
Yeah, for sure. And I want to hopefully link up if we're ever on the if I'm on the West Coast, you're on the East Coast, but I gotta click a pause on this version of the episode, or this version of the podcast, and call it quits. But I really, really appreciate everything that you had to say and being a guest and all your insights and everything. So why don't you just tell us where people can find you if they do need you? I know you're in San Fran.
Right. So I'm Anderson Franco. You can find me at andersonfranco.com on
By the
social
way,
media.
I'm not suggesting you just show up to Anderson's office, by the way, but go ahead.
But just you could contact me. You could shoot me a text message or email on andersonfranco.com. I'm on social media platforms. A lot of my social media platforms are Abogado Anderson. I present a lot of Spanish content about personal injury. So contact me for claims in San Francisco Bay Area.
Thanks, Anderson. Appreciate
Thank you.
it. All
Thank
right.
you, Tom.
And that's a wrap for this episode of City of Brotherly Law. I'm Tom Bosworth, reminding you that in Philly, we don't just practice law, we live it, we breathe it, we fight for it every day. This city was built on grit and determination. That's exactly how we approach justice. That's how we approach cases. Join us next time for more straight talk and legal insights from the heart of Philadelphia. Until then, stay tough and keep it real, Philly.